Welcome to LexTalk, World's talk show presented by Flickr Creators. Today, we have Mr. Surya Narayanan Gopalan with us. Mr. Gopalan is a practicing advocate in Madras High Court and Supreme Court for nearly 3 decades. That's 30 years. He is the founder and senior partner at GSJ Legal. His expertise lies on a lot of things, just to mention few: commercial documentation, real estate documentation, banking, finance, and is advisor to several corporates and banks. And as you see, there are a lot of points that we can discuss about, and this is going to be a really interesting session. So without further ado, let me introduce you to the man himself. Hello, Mr. Gopalan. Welcome to the show, and how are you doing today?
Yeah, today I'm fine. How are you?
I'm doing great, sir. Thank you very much for asking, and thank you very much for getting some time out of such a busy schedule that you have. I know it's very difficult for you, but I always appreciate that. And I tried my level best to cover things about you, but as I said, 30 years cannot be summarized in just 4 or 5 lines that I have written. So my first question to you is: you've been a legal professional for 30 years. How was the journey? What was this all about? How it started and where it's taking you?
Yeah, I was the first generation lawyer. So my journey was really tough for the first 10 years, where literally I had to put in a lot of hard work. I, I literally took all the materials, I studied more, I drafted more, I put in a lot of effort in court. I did lot of matters, trial matters, appellate side matters, writs, everything that come on my way. I did everything. And by end of 10 years, I got a name that uh, started taking me to the next stage. From 10 to 20 years, I have been from almost 50 year, I started my legal research, where I have been doing some work for Law Weekly, a magazine. Then I was also doing some work for All India Reporter, which is also a law journal. I was also doing my independent law research to keep myself updated about the law and the happenings inside the court. Therefore, next almost till 20 years, I was only spending my time in office and with the books. That was the journey for 20 years. From 20 years onwards, I have been a chief editor for a law journal called Madras Civil Cases. From there, I also published a book on Tamil Nadu Court Fees Act, Court Fees and Suits Valuation Act in 2017. Later, I started doing lots of cases as my own case as well as senior engagement in High Court as well as Supreme Court. I appear in almost all the tribunals and courts in Tamil Nadu as well as I've done many cases in Supreme Court.
That is really wonderful, sir. And I'm sure that there are a lot of things that you can suggest to the young generation, but we'll keep that question for the last, because there are a lot of young professionals that watch our session in order to make good in the industry. But before that, you also said that it's important. I mean, you're talking about being updated with the latest laws. How important is this? I mean, we hear a lot about that you have to be really updated with latest laws, not just national but international. Depends on your practice. But how important is updating to the latest law and the case laws in lawyers' day-to-day life?
Definitely, unless a lawyer knows almost all the laws that he is required to for his practice, he cannot draft even a smallest of the petition that comes to him from his client. He should know what the client right is, what is that he has to put as pleadings, what is his client's right. When he writes a pleading, it goes before the court, it is tested by a third person, who is a judge, who has lot of experience. Therefore, the judge should be convinced from your pleadings to have a right. That right needs to be addressed by the. To have a right, grievance is there. That right and grievance has to be addressed. That is very, very important. As far as the updation of case laws is concerned, yes, because nowadays, almost in many of the cases, the court says you can do it, you cannot do it. Unless you know the latest, you cannot go stand before the court and test yourself. That is not possible. Therefore, I will always advise that you should keep yourself in the best of laws and as well as the cases.
And what does it really mean for young lawyers to remain updated with the latest law? I mean, I what I understand is someone like you
Today, what
is
is happening is many of them browse Google and say, I know this. That cannot happen. That is not the way one can look into in law and medicine. You cannot learn law and medicine by browsing Google. Law and medicine is particularly law requires lot of effort. Sit with the book, spend hours. That will help you to see how the case has been dealt with, how the pleadings has been written, what has convinced the court, what has not convinced the court. That will help the lawyers to see, yes, if I do this, I'll get an order. Because it is always that a client wants an order from the court. A successful lawyer can only say, I am successful only if he is getting orders. Whether it is court practice, arbitration, or in any other mode. Unless you show success, the client will not be happy.
That's right. That's very right. We'll come down. I'll come down to arbitration. I have a very interesting question for that. But before that, you also talked about spending time with books and of course journals. Another synonym for lawyers. But for how does it help or how does it become important when it comes to drafting pleadings and court craft?
Drafting pleadings makes you get the judge convinced. The court craft comes next. If you can get your pleadings on to the dot, mostly you have got the order. Yes, you will have to appear and tell convincingly to the judge, depending on the day, this is what is happened. I require this. That is court craft. Normally, you have also face value in India and almost many countries also I've seen. But face value will not alone get you orders. The court craft is very important. You will have to listen to what the judges say. Because listening is an art of answering something that comes back to you. You will have to answer the judges the questions that is posed by them. That will get you the orders. Convincing reply to the judges.
One interesting question that's coming to my mind is the results. We also talked about results. Everybody, clients, everyone wants to see results. Success, basically. How lawyers train to get results? I mean, it's a business of law, and not really a business, but if I have to portray it that way, it's a game of laws, and not really justice. So, how lawyers train to get results?
See, when you look at the papers itself, you know what is your take. How best you portray what your client has in the papers, and in the surrounding circumstances, the lawyer has to do it. It is the way the lawyer gets his pleadings and argues in the court that gets him the orders. In almost all the cases, you cannot say both sides should win. That cannot happen because both persons will come to a lawyer only to win the case. A will come and say, I should win. B will go to the next lawyer and say, I'll win. So, only thing is that both lawyers should try their extreme. Test themselves because every day is a test. It is not that you have won merely because you have spent some time inside the court. Every day is a test to a lawyer. How you win the test every day gets you the result.
That's really wonderful. I mean, that's a very wise way to listen. Mr. Gopalan, I'm recently actually asking this question to a lot of lawyers, especially the young lawyers and the new generation. But I don't want to miss this opportunity. I mean, we really get someone whose experience is like 3 decades. So I don't want you to leave without answering this one. What do you think mediation? I mean, what will you pick, mediation or litigation, and on any given point?
On any given point, as a litigation lawyer, I should say, yes, I'll go for a litigation. But as far as commercial litigation is concerned, the parties know the right when they enter into a contract. There might be some ifs and buts because the parties themselves do not create the contract. Third parties create the contract. There will be some gap. During the performance also, the situation will definitely change. The interest in commercial matters is only commerce, which means money. Truly money. Truly money, or in the end, the goodwill and reputation to the company. That is the end result that is required. In commercial matters, I will always suggest, if it is possible, mediate rather than litigate. Because win-win situation arise where the parties can decide their rights. Yes, I stand here, I take it.
That's right. Is there, I mean, I'm not sure. Mediation still, I mean, I've had a discussion with another lawyer, and he said that the success rate of mediation is too low. I mean, many maximum cases, it again comes back to litigation. So it's just that
Absolutely,
they're spending
because
more.
see, here in India, we have only court-directed mediation. Now, outside Asia, you have also outside mediation, like you can enter into an agreement, you can go to the mediation center, show that, or you can enter into a mediation agreement there itself, they'll give you the forms. You can agree, enter into an agreement where it will be more like a jury place. They will fix a place that is favorable, that is so conducive for the mediation. The parties will be asked to appear for a joint session, individual session, private session. Then in many of the cases, the mediator will also have some, what you call, an event of cross-examination in some stages where you will have to do it to get back the parties to their place where they have to stand. So that event will also happen in the private session. And after that, you will find out the interest as well as the end of what is required for the parties. From there, you can proceed. In the court appointed mediation, what will happen is, in many of the cases, the parties, many of them are illiterate. They go with what the lawyer says. The lawyers naturally will require, if they retain the brief, they'll get money. So the lawyers will always say you litigate. Unless otherwise the party is going to say, I'll give you a portion. But that is illegal again. I will not advise that that should happen. Again, it is illegal. That should not happen. But I have seen as a mediator, I have seen there are many cases which we go saying that this will not happen. It happens, it gets mediated, it gets settled in mediation. In many cases which should get settled, it doesn't happen. You cannot say this is it is because of this event it did not happen. It has happened, that's all. You will have to live where it has ended.
It's always laws and it's always lawyers, I believe. What's your take on arbitration as a tool, sir, and the inconvenience faced in our country then?
As far as India is concerned, arbitration till 2015 was a very difficult process because the parties had the right to appoint their own arbitrators, and 34 the courts had very, even today courts have very limited right of interference in the award. After 2015 amendment, and the parties can appoint, see, in any event, the arbitrator can take only 2 matters of a party. More than 2 matters, he cannot be an arbitrator for a party. He should not have advised, he should not have arbitrated for him prior, all those conditions are there. So that way, some control has been brought in. Still, see, arbitration today is not a substitute to the court. Even in foreign countries, arbitration is not substitute to court. But there, at least, what is happening in international arbitration, to my knowledge, is that the parties go there with a fixed time frame. They get the result, and the result is literally is in terms of contract and the law that governs.
Mhm.
That should happen here also. Once that is happening, the parties will be satisfied going to arbitration. And the time consumption, see, 1 year or an extension of 6 months again for a commercial litigation is too much. You go to an arbitrator for a quicker result. The parties cooperate, the arbitrator should at least try to complete it in.
Yeah, that's right. I mean, it depends what sort of case, as you said, and every case had its own complexity. So it's on you, sir. It's on the lawyers, I believe. Clients are really important for lawyers, for any business, I believe, and not just for lawyers. But in that, it's a lot of complex things that we don't understand as a layman. Even the clients don't understand really. How important is transparency in proceeding and communication with client for legal profession?
Very wonderful question. The transparency to the client starts from the way you discuss with them. You'll have to discuss the pros and cons, tell them this is where you stand. This is your right, this is where it is infringed. This is where you can get protection. These places you will not get protection, but you can try. These places you will not get, you should be very fair, first aspect. The second aspect is, when you draft a pleading, always involve the parties, send them the draft. Tell them this is what is the draft you approve if he is learned. If he is illiterate, explain to him what is there in the papers. Give him one copy of what is filed inside it. Scan the copy of his with his signature. This is not only for the party, this will save the lawyers also.
And in saying
And
the lawyers, you
when
mean
the
the
results
reputation.
come, whether it is victory or failure, the party is going to face. You cannot suppress and you cannot do anything. Just go to the party, fairly say, this is what happened inside the court, we did this, who have lost. You have a right of appeal. If you want, we'll proceed. Or you take a call, what you. This should happen. That is transparency. And transparency to the court and to the other side. What is transparency to the court and other side? You cannot see, I cannot give my papers, everything to the other side and say I'm very transparent. That cannot happen. How I am transparent is I am giving him all the copies of papers that is filed inside the court. That is the transparency I am expected for the other side. As far as the court is concerned, what should be said should be said. See, there are certain statements which cannot be said that would create a bar, but you cannot suppress that. It should be said in a way that it does not amount to a bar or it takes away your right. That is the craft of a lawyer.
That's very wonderful, Mr. Gopalan. You also talked about, you touched upon drafting and then you sort of left it. How important is drafting in legal proceedings? Why is it so important?
Drafting means case. If a plaint is filed in the lowest court, it should go till the Supreme Court. The Supreme Court should say, from this plaint alone, I'm granting you a relief. That is how it should happen. See, I'll tell you an instance. I do not know whether it is a success or it just happened. 2 weeks back in Supreme Court, I have been on the respondent side. I filed a counter with some papers. When we went there for the hearing, from the counter itself, we have won the case. The judges told the petitioner that you don't have a case. You have been dragging the matter for 12 long years. And the landlord has to get his property. Therefore, you will have to go. In civil and commercial litigation, definitely your pleadings wins the case. Because in commercial litigation today, you can ask for striking of vexatious and scandalous portions of pleadings. Then you can ask for summary judgment. You can also seek for what you call the judgment based on admission. So when you draft a pleading, either as a plaintiff or defendant, you should be so careful that it does not amount to an admission or it does not amount to going to the extent of getting your pleading striked off.
That's why it's sort of like the foundation of everything.
Being a civil and commercial lawyer, litigating lawyer, to me, always go with a frame of mind that gives you the best for the drafting. Sit with that frame, do not get distracted. Finish your drafting, do the other one.
Yeah. All right. That's for all the young lawyers and of course for everyone. Some good points and some good nuggets to take on. Mr. Gopal, this has been a great session. I have a really funny question and not really a controversial question, but I need an honest answer from you. I'll ask the funny one first. Do you really see clients coming in? Sometimes you see everybody see clients coming in who are smarter than a lawyer. You see they're just trying to get into your work.
Definitely. See, Mofsal clients are more smarter than the persons who come from corporate are also. I will not say corporate, they are not smart. But the Mofsal clients will show more smartness in handling the litigation and lawyers. They'll say, I know this. This is my right. This is what he has done. You will have to put it only this way. They'll guide us, literally. When we say this is your right, you will have to restrict. They'll say, no, sir. It cannot happen. This is my right. You canvass this right. What we'll do is we'll say yes. We'll also put the point, but we'll modify it in the way that we also require it. So we satisfy the client, we satisfy ourselves, both is done.
So yeah, the answer is that you get these sort of clients. Yeah, okay.
But
And
even
it's very often.
corporate clients also some events happens where, see, many of them will require the drafting. It will be sent. There will be lot of people who will be looking into the draft. They'll have lot of people also who will be, see, some will be having the authority to approve, some may not have. But later, some people will say, sir, we did not ask you to do it. But in all these cases, what should be done is, there should be a confirmation from the client that we can go ahead, proceed with the pleadings as sent, or with the instructions as required.
Does this happen very often with you?
Yes, this happens often. And if you don't get that confirmation, that is the issue that crops up often. It is always better. The client comes, gives you instruction, then you do your case. There are some instances where the court will insist you to argue. You can tell the court you don't have the instructions on all these matters except those that for which the pleadings are there. Pleadings and documents are there. Thereby, the lawyer can definitely save himself.
Yeah, I mean, of course, lawyers are the best to be aligned with the laws, not the other guys. Now the other question, sir, because you have 30 years of experience, and why I'm mentioning this again is you've seen legal industry travel from papers now to paperless, and a lot of things happened, especially from 2020 and till now. But few things never changed. I'm talking about the pendency and the justice gap that is there. What do you think? Why does it? I mean, why is a justice gap? First of all, do you see a justice gap there? And if it is, why is
See,
it?
I
And
will
what
not say it
is
is
the
a
movement to
justice
do
gap.
it?
I will not say it is a justice gap. Please understand, for this huge amount of population, you cannot provide courts in every corner. It is not a Vinayak temple to provide courts in every corner of your country. Courts can function only within the jurisdiction that it is provided. Today, what is happening inside the court is the best things that one has to see. I would say they are working very hard to fill the gap and clear the pendency. There is lot of pressure on the judges to clear the pendency. One cannot say there is a gap. But one thing I wanted to stress is the online hearing should go on. That will fill the gap of a person approaching a. See, a person from remote corner of Rajasthan has to come to Delhi. It would be very difficult to travel if he knows that his matter is posted in Supreme Court in the evening. Then to travel, or from south to go there, do a case. If there is going to be online hearing everywhere, that hybrid hearing everywhere, it should definitely fill the gap. There may not be more pendencies after a few years.
Remote proceedings and availability is another
Yes,
option to do that.
yes, because see, commercial, there is pre-mediation that has come in now. For commercial litigation, compulsory pre-mediation. You will have to go in for pre-mediation, then alone you will have to come back to the court. See, a mediator cannot give a report end of the day that so and so is in mistake. Therefore, he is liable for a cost. That cannot happen. Because mediation is a process where transparency and the credibility of the mediator should settle them. The mediator should not send any noting to the court. That cannot happen. But in pre-mediation, there is every possibility that 80 to 90% of the commercial matter may get settled and should get settled. Because there is no ego here, individual ego involved. It is only the interest of corporates.
Oh, that's right. That's right. It's just the party's interest in that case, I believe. This has been a great session, sir. Your experience is sort of just pouring out in the session, and I guess you're all sort of ready to have that, especially the young lawyers, as I'm mentioning again and again. But talking about young lawyers and having such a great experience in your hand and so much variety in your hand, what are your suggestions for the young generation who are entering the law and have already entered and trying to make big in the fraternity?
If you want to become a litigation lawyer, learn all the laws. Whenever possible, sit with the book. Don't browse over your internet, read. Sit with book. Sitting with book gives you more the attitude to work. One can ask me a immediate question, sir. I am sitting in front of a computer for 20 hours. I am working. Still, I am the most successful. But see, reading from book enables you to make your concentration only there. We'll say the horse's eye, which is tied to that particular portion alone. Therefore, that is what is required. Go sit with your senior in your senior's office, toil, learn, take it as a parents. Sit there, do all the works that is given to you. Learn your clerical work, learn your table work, learn manners. Today, you cannot just like that go and represent to a judge. I am representing folks. Immediately the judge will say, I don't want here. Ask the counsel to appear. So when you go represent the court, have respect to yourself, respect to the court. Respect to you will come only by the way you conduct yourself. Learn all those basics. Once you learn the basics, automatically you will learn to represent in court, you will learn to write. drafting will come, because when you see lot of things happening in front of you, that will pour you as ideas for you to draft. That will come handy before the court and say, this the lawyer was saying he was successful, this the lawyer said he is unsuccessful. The court did not encourage him. I should not represent this way. That will definitely come to you. Very well, the today's lawyer generation, I would say, the present generation is the best. They are quick learners. They are quick learners, very quick learners. Definitely, they are where they have very better future. I wish all of them to be very successful in this field. In fact, we in this pandemic, we trained about 10 to 12 lawyers in civil and commercial litigation. We took it as a course. We made them to, we conducted lectures. We made them to write pleadings. There were a panel of lawyers who corrected it. The lawyers, what they will do is they will give marks only for the completion of provisions and the manner in which pleading should be done. As far as the merits is concerned, they will individually discuss with the lawyers and tell them, this is what you should draft, this is how you should draft, this you should avoid because this will not give you this.
These are such wise words, Mr. Gopalan, for everyone, especially for the young lawyers, which the message was meant for. Uh, I have enjoyed this session. I love this session. And as I said, there are a lot of nuggets that I've taken, and I believe our viewers as well. And I hope you also enjoyed this session.
It was very nice session. Thank you for this opportunity. Let's talk and click away creators. Have a very nice day. Thank you.
Thank you, Mr. Gopalan, for the session, and we all enjoyed it. And we look forward to having a chat with you again in the future on some other trending topics in the international legal industry. And for our viewers, if you like this chat with Mr. Gopalan, I want you to like this video, to share this video, and click on that red button to subscribe to ClickAway Creators YouTube channel to appreciate what we do. And you have more coming in from legal industry leaders. This is Sagar for Let's Talk World, signing off again.